Audio. Facebook. Sasa jua isikuje.
Kitu nataka kamera
stabilize. But pia tukiloko hapa itaacha kucheza. Yendaka Allen key.
Uko inazunguka.
Allah. Nimejishindwa kwani uko na radio cool leo.
Kulipa huyo. Kulipa huyo kutoka. Lakini utaiba kila mtu bwana. Watu wazuri unaiba.
Ujinga wasibo. Poa sana. Sijibora alikuwa nikusike na usinde.
Zakire.
But jua ikizima hivyo tuko na picha. But hii ndio entry. Hii ndio entry.
Nataka tucheze clip ya nani hapo.
And the other process will take place. We are ready for any process that might be commenced by the DPP.
What do you anticipate in terms of the process?
We do not know whether they have just said they have a charge sheet.
Okay.
We have to see it.
Yes.
Number two, of course, we expect that we're going to make an application for bail.
Okay.
They may oppose it.
Yes.
Of course.
Yes.
And then we'll put our best foot forward and we shall leave the court to make a determination. The other thing is that I also hear they may also bring miscellaneous application. I am not sure.
Okay.
Yeah. Remember, the rest have not been arrested, yes?
Not yet, yeah.
Yeah, they are just co-accused.
That's right.
They have not been arrested yet.
Okay.
And they have not been charged.
Not yet.
Neither have they then been investigated.
Yes.
Yeah. So just ask our supporters to continue supporting the process.
That's right.
This is an ulterior case.
Yes.
That is commenced for ulterior motives.
Yes.
With a view of intimidating people to silence. But we are telling them in a new constitutional dispensation, at least one of the bare minimum is the freedom of expression. That is the bare minimum.
That's right.
And we shall continue to execute it now,
Yes.
today, tomorrow, and even in the future.
Thank you, Akili.
And we shall not be intimidated whatsoever.
Asante.
So we expect Senior Counsel Martha Karua is coming.
Excellent.
She'll be the one leading us as a Senior Counsel.
Thank you.
Senior Counsel Karonzo Musyoka will also be
Around?
Will have been around, but is attending his father's funeral.
Okay.
We expect Wakili Eugene Wamalwa.
Yes.
Albert Simiu,
Yes.
Kibe Mungai,
Yes.
and others.
Thank you.
So we have a battery of lawyers to tackle the DPP, and we are equal to the task.
Thank you, sir.
Yeah.
Nimerudisha. Hata funga hii LCD acha nitumie ishi. By the way, itanisaidia hata.
Inaonyesha code
Yote kubwa.
kuna huge ndio. Alafu record kwa nini?
Nifungulie kwenye LCD nione kama ina record. Fungua kwenye LCD.
Nataka mletee big one.
He has no reason to reopen this matter. Litigation should come to an
So,
I think we can consult a bit.
yeah, we can consult a bit.
The other lawyers are coming. We are some.
Nataka kutega hapa.
Mana sisi cepat sekali. Nah, anak kamu masuk di abis di kali kota.
Tunaenda kama mbele ya zeka. Ndio hapo ya dapo sana. Bora. Sina nini bora.
Ndio ndio kama kuingia tuingie saa hii. Je, ni mwana ile Subaru. Mwana ile Subaru. Nzuri.
Usitushika wewe.
Haya, mimi sishiki wewe. Na kwa mrembo unaweza tokea picha mzuri. Una reflection yako venye iko safi hapa ndani. Sawa, siwezi kushika. Sawa.
Alfred, and then tuko na watu wawili from me. Alfred is my student. Yes. And two officers. Yes, and two officers from yes. Yes. All right, sir.
What do you know about them? The last.
Yeah?
No, you're right on time today. You're right on time.
Hey, Dani.
Nani? Here with you. Sini watu wamesongesha tu, mimi ndio naseti hapa na wewe.
Hata mwingine anataka kitu kanaka nini katika
sasa tutakuwa sauti.
Chukua vitu vyenye unataka, nipe bag niende. Yes.
Unaziita ndio hivyo ndio tu.
kama mnakuta mwili toa mwili
akisimalize guy kwa shoti yangu
wewe
Panga alafu ukae hapo.
waulize tukipanga
naomba
anavuta zikikatika
number E024 of 2025, Republic versus George Natembeya.
Walubengo Waningilo.
The last name?
Walubengo Waningilo. You just been served the charge sheet now. They'll just get go on record.
You have not commented about the second.
Kenya shillings 1,127,900 from Mercy Chelagat, the director of Lima Agro Science Limited and the proprietor of Myra Stores, the beneficial owner of Easterly Wheels Limited, which traded with the county government of Trans Nzoia. Is it true or not true?
It's not true.
The payment made by public government of Trans Nzoia to Lima Agro Science Limited, Myra Stores and Easterly Wheels Limited in conflict of your public.
No, Your Honor, by the prosecution to purport to court the directions you need
We believe that because we oppose bail, and bail being ordinarily a right, then it is has to go first in an application to oppose bail. Then we take the court through the affidavit, the factual matrix. Then we take the court through the affidavit, the factual matrix. Allow me to take the court through the legal matrix. And I'll start by indicating that the law on bail is almost application in Article 50 here, sections, and that every arrested person or an accused person has entitlement to bail. I am normally wrong, so I may be wrong to preempt them, but I promise they will say what I'm telling you.
If you can give,
I promise they will say what I'm telling you.
if you can give them a chance,
The council,
if you can give them a chance,
the council to deliver,
give them a chance.
the council to deliver, just speak for the state which it represents.
A minute.
To deliver, just speak for the state which it represents.
A minute.
Speak for the state which it
A
represents.
minute.
The accused has sufficient defense.
Decorum.
Accused has sufficient defense.
Decorum. I repeat. Decorum. I repeat. Third time. Decorum.
It is strike law that the denial of bail where there are compelling reasons is not a breach of the presumption of innocence. Then I trust the court to have a look at Chomli case. I'm not very good with the spelling of the pronunciation of the word. We do not have copies of that authority, but because this court can notice there, the Tom Chomli case is clear on the relationship between the right to bail and sorry?
And the High Court level or Court of Appeal?
The High Court, sorry, the High Court.
High Court level.
Yes. And therefore that if this court finds that there are compelling reasons, or at least one, Your Honor, because just one compelling reason is sufficient to deny bail, then that does not in any way breach the presumption of innocence. Your Honor, I will also invite you to Article 24 of the Constitution, vis-a-vis Article 25 thereof, on the limitation of rights under the Constitution. And the effect thereof is that the only rights that cannot be limited are the rights under Article 25. And that the right to liberty or any other right that may be alleged to be violated, including the right to presumption of innocence, by denial of bail, can be permissibly limited by dint of Article 24 of the Constitution. The net effect thereof is that a denial of bail where there is compelling reason or compelling reasons amounts to a permissible limitation of a right under Article 24 of the Constitution. Whereas a compelling reason has not been defined by statute in Kenya, we have guidance from the Judiciary Bail and Bond Policy Guidelines, Judiciary Bail and Bond Policy Guidelines, together with several decisions of superior courts in the land, that is the Court of Appeal and the High Court. And Your Honor, that the list provided in the Judiciary Bail and Bond Policy Guidelines is not exhaustive. But without going to the particular facts which my learned senior Mr. Kula is following me to talk about, that list includes, as compelling reasons, the likelihood of interference with witnesses, the likelihood to interfere with ongoing investigations, and the likelihood to interfere with exhibits. In concluding on the legal issues, the primary purpose of bond is to ensure that an integrity of the trial before you. protection of the integrity of the trial before you. So that, Your Honor, even where it is shown that an accused person shall turn up for trial if released on bail, where releasing an accused person on bail will prejudice the integrity of the trial. We are releasing an accused person on bail, even when it is shown that they will attend trial. We are releasing them on bail will prejudice the trial, and therefore the integrity of the trial. This court has a reason, a compelling reason, to deny them bail. And Your Honor, a likelihood to interfere with witnesses, exhibits, or ongoing investigations is a high likelihood of interference with the integrity of a trial. That is our submission. Allow me to say the last thing on Section 8, subsection 2 of the Magistrates Court Act. Section 8, subsection 2 of the Magistrates Court Act deals with the court's jurisdiction, I mean subordinate court's jurisdiction, to enforce Bill of Rights or questions of interpretation relating to Bill of Rights. That jurisdiction is limited to Article 25A and B of the Constitution. The rights under Article 25A and B of the Constitution. It is a clear statutory statement that this court's power to enforce Bill of Rights is limited to the rights under Article 25A and B and nothing more. So that, Your Honor, reference to constitutional provisions as regards Article 49 on bail can only be made in respect of 25A and B. Anything outside of that is outside your jurisdiction, and where you have no jurisdiction, you pen down on those questions of constitutional interpretation if raised. I am honored to appear before you. I thank you and invite my learned senior, Mr. Kula.
And we have filed an affidavit sworn on 19th May 2025 by Mr. Robert Swan. 19th of May 2025, this morning. Sorry, yesterday, Ronald.
That is where it got started.
Yes,
19.
we filed this morning.
5.
Yes, sir. It is sworn by Robert Bono.
Sworn by?
Robert Bono. The ESCC forensic examiner. There are the factual reasons or grounds to reject bail are defined from paragraph 1 to paragraph 12. However, I will cluster them into three. 1 to paragraph 12. And however, I will cluster them into 3 compelling reasons. The first one, interference with witnesses. The second one, public safety. And lastly, the severity of the offense. For the first compelling reason, my Lord, we submit that subject to this case, there are other ongoing investigations which at paragraph 3 and 4 confirm that paragraph 3 and paragraph 4 of the affidavit confirm that the accused person, through his agents, attacked EACC and LPS officers in lawful exercise of their duties. This has been reported and is captured under annexure number R38 at Kitale Police Station. R38, PR38, annexure PR38. Your Honor, we have a next photographs of security vehicles.
With your kind permission, I wish to raise an objection. And my objection, Your Honor, is founded on section 106B of the Evidence Act.
That is your name?
Willis Otieno, counsel for the first accused. Section 106.
Yes,
Section 106B.
on electronic evidence.
On electronic evidence.
You get your time.
No, I wanted to raise an objection because it's time to refer to it.
You get your time, let it continue.
Also, we have a next
I want
evidence.
to conclude the direction first.
Yes, Your Honor, we have a next series of photographs marked as RR1 to RR37.
1, 2, R,
37. Your Honor, Those photographs depict vehicles belonging to EACC and National Police Service that were vandalized at the residence of the accused person. Yesterday, when the officers were executing their lawful mandate.
Executing?
Their lawful mandate. That is, doing a search pursuant to miscellaneous application E716 of 2025. E716 of 2025. That is detailed in paragraph number 4. Now, photographs RR3 to RR10. RR3 to RR10. They depict motor vehicle KCH 046T.
Come again,
46T. After it had been vandalized. Then our photographs R11 and 12 depict KCD 628X. Photograph R11 KBU 734Y. And photographs for U, ACF 541U. At paragraph 7 and paragraph 8, the officer deposed. At paragraph 7 and paragraph 8, Mr. Rono deposed in these vehicles. Important documents were taken. Now we take judicial notice of the position of the first accused. The witnesses in this case, Your Honor, upon disclosure, are his subordinates. People employed under his government. What is the test of interfering with witnesses? It is not beyond reasonable doubt. The test is just a reasonable prospect that the accused may chamber with the witnesses.
The test is?
A reasonable prospect that the accused person will tamper with the witnesses or the evidence.
perhaps, and I'm aware of the directions you've given about the decorum. Perhaps we need your guidance whether counsel can go outside the content of his affidavits and claim to bring averments that are not contained in the affidavits, because that will prejudice us in terms of our response. Because there is no averment in the affidavit to that effect, that the proposed witnesses are the subordinates of the government.
I'll give a guidance again. Wherever you pick along the way from both submissions, kindly bundle them together. Once you rise, I expect that you address all the issues in one sweep.
I'm on the way.
But let me record you first. Structural witness I need to record his objection. Everyone,
I will repeat your argument.
How long more? I thought we were going to take 3 minutes. Now we are going to we sit here the whole day. Just off the cuff. How long more?
I'll tell you. Just summarize this.
10 minutes.
Yes, sir. I will repeat that.
You have 10 minutes.
We are submitting that once disclosure is done, the witnesses will be calling our officers from the first accused country. Those are disability. I'll go to the second limb, severity of the offense. I'll go to the second compelling reason. When a perusal of the charge sheet, the amounts will appear casual.
The amounts will appear?
Minimum. 1 million. But we believe, Your Honor, will win this case. And we'll draw your attention to section 62(1) of our second. 62(1) of our second. In the event we succeed, that provision is very punitive.
In the event?
We succeed.
We is the
DPP.
The DPP.
Prosecutes this case and we get a conviction.
If success decree?
Yes. We will be moving to section 62, subsection 1. And you know that the severity of corruption cases for someone to interfere is subject to the positive. Lastly, I've alluded, Your Honor, to what transpired yesterday. And I've said that investigations with regard to other cases are ongoing. Our submissions is that if we release the accused person today, what transpired yesterday, Your Honor, will occur. And we are apprehensive that in the interest of in order to protect the integrity of the criminal justice processes. A plea bail report we agreed before this court and decide on this matter. That will be a
Sorry, Your Honor. Just to underline that our prayer is that the first accused be denied bail. That probably is the last sentence you have done. Thank you.
How many of you
Please, I'll take the first one.
Because I listed, how many? Listed 11.
Yes, and one. Not all of us, certainly.
So how many? Just to manage our expectations.
About five. About five or that would be brief. We do it on the line. We don't want to drama, we just want to go to the issues. You know, because the issues are straightforward, Your Honor. But let me start by introducing Senior Counsel John Kaminwa. He's our guide.
Okay, Your Honor. Good morning.
Good morning. Karibu.
So we have an opportunity. Then Aaron Dubi. Aaron Dubi is also here. So that is Aaron Dubi. Your Honor, let me be the first one to just give some. Your Honor, let me at the outset state that the prosecution is causing unnecessary drama in an otherwise straightforward matter. And our focus at this point should be the rights of the accused person, who remains innocent unless and until he is proven guilty. So no amount of reasoning. Yes.
Yes.
So no possible grounds can be advanced that can be directed at taking away the accused person's rights. That should be the starting point. Sometimes, Your Honor, as a counsel, it is factual. It is factual. It is factual. It is factual. When we propose,
but I'm sure Dr. Hamino is smiling at you.
In fact, I'm one of the few who have the advantage of having interacted with you in my previous position in JSC. I know you have a very sharp mind. We don't need to come here and start the previous position in JSC. I know you have a very sharp mind. We don't need to come here and start
citing to you positions of law and affidavits. So I cannot, by any stretch of imagination, expect that a court.
I'm making a backup for the. We don't trust technology.
The technology.
I'm making a complete backup for technology. You can continue.
So I dare say, Your Honor, that even the prosecution, because they're also lawyers, we all pass lawyers before we end.
Sorry, Your Honor. I know the court warned us of decorum, but we plead. I am just 12 years in practice. We plead that senior Macharia doesn't get personal.
There is a special reason, Mr. Njeru. I did what I did to your side. So that we remain focused.
Yes. With tremendous respect, what we have here is lawfare, which I urge you, Your Honor, to take judicial notice of, because we live in this country, we are interacting with social media, we know what is happening in our country today, and none of us can purport independent agencies are being captured and being used to weaponize matters of justice. That's what lawfare is all about. We use legal processes to attain an ulterior objective. Your Honor, I'll make a confession to you. I was, and you shouldn't allow it. Your Honor. I'll give the context. I'll give the context. I'll give the context, Your Honor. Yes, I'll give the context.
Focus here, Mr.
Yeah, context. I'm not here to talk about where I was and
Sorry, Your Honor.
It's just to indicate.
Sorry, Your Honor, we are forced to object once more on the question. The factual matter is that, with respect, he cannot tell us from the back. We would believe him, and I know he's a very truthful man, but for us to believe what he's telling you to believe, let him give us an affidavit of those facts so that we're able to respond to those facts. Without that, we humbly plead again. We humbly plead that he gets back to the case and not tell us the other things that are factual and there's no affidavit. We plead with him. We understand that he's previously the commissioner. We understand. But let him get back to our case. Thank you.
Look at the affidavit.
A minute, Mr. Njeru. I complete reporting.
Your Honor.
Mr. Njeru, your brief response, you're responding?
They've made general averments. To start with, problem number one, they serve us in an affidavit this morning. We expect us to make an application for adjournment so that we can file an affidavit. And in the meantime, they accuse. Then the affidavit itself is marred with general averments. not respondents agents. They are not naming which agents.
Oh, just to be clear, you responding to the objection or you continue with your submission?
I'm responding to
That
the
I'm
objection.
clear.
Yet in his own affidavit, he has made very general averments that are in support of denial of bail. Then he respond to that, at least from the back. At the very least, that should be expected. He can't have a steak and eat it. The subject of these proceedings is the accused person. The rest of us are speaking here, and then we'll walk away. But this is the subject. That's the person you should focus on.
That is the issue on the table. Continue, Mr. Diego.
Much obliged, Your Honor. Now, including very sensitive security agencies. And he also understands the law by his own right. He understands his obligations to the public security. In custody for this kind of charge. Why? It can only be for, and it is that desire to continue punishing him that is driving the application for him to be denied bail. You cannot allow yourself to be used. I have consistently said that the last line of defense for this country, the only one remaining, Your Honor, is the judiciary. And let's not think. So regardless of what happens here with these protracted submissions and responses and counter submissions, not fall under the trap of saying that you're going to write a ruling another day. In the meantime, he remains in custody. Don't allow this man to remain in custody. He's already been punished enough by being put in custody, even for that one night, when he could have been summoned to appear in court and he would have appeared. One of my colleagues here will speak about the facts, then Chesa, but I can tell you, Your Honor, the reality of our times is that between now and 2027, these are the kind of things you're going to see continuously. Plead with you. Do not fall into that trap. I'm confident you will not do it.
Thank you. Your Honor, just to associate myself with the submissions made by Malala and Celia, drive the mischief. That the accused person is currently...
Slower. Pause after every sentence.
Is judged before you with another person, Wafula Masungo, who is not before you. It is not that Wafula's whereabouts is not known. it's because Your Honor to perpetrate this mischief. In almost for explanation, Your Honor, my lad senior indicated that he was seeking summons. It's the same mischief, Your Honor. The opposition, Your Honor, was that you seek summons. Was not indicated to you. That is to say, must be read in light of that mischief. That other than pursuing other ulterior motives that are politically actuated.
Apologies. You directed.
Me, I'll bring you direction.
Colleague is submitting on a fact. Unless he has evidence as to what he wants to speak about, we would ask him to take the rest of the accused person. Let's not impute ill motive to anybody unless they are willing to take the dog and ready to present.
Is contained in the affidavit filed by the ODPP. That's not surprising, Your Honor, that the affidavit contains it has no tangible evidence that proves to the contrary. If I was to proceed, Your Honor, in response to the substantive application,
Must be direction on the objection. Belong to the law on bond and bail, avoid instances which may persuade me to request for fact.
The affidavit contains mere speculations. There is no averment in the affidavit.
After every sentence,
before you, the averments in the affidavits have no nexus with the charges before you. Neither the prosecution, nor the defense, nor the court are privy to. Would be tantamount or will amount to violating his constitutional rights. And most importantly, the right here are subordinates to the governor, the accused person. Again, is not contained anywhere in the affidavit. Has no probative value of whatsoever nature, and the accused person. And as such, that cannot be considered to be a compelling reason. More annoying, Your Honor, more of KCH 046T. It will not tell you the registered owner of KAE 7.8F. It is guided by the Registration of Motor Vehicles Act. And if you are courteous enough, as I pen off and invite my learned friends, to draw your attention to the charge sheet once again, that there is no charge where there is a charge of conflict of interests. To look at Article 50 in isolation of Article 25, in light again of Section 8 of the Magistrates Court Act. From Article 25, he tells you that the question. If you look at the law, Black Laws Dictionary, it will give you as to what is deemed to be compelling. No evidence produced. No law quoted. No case law. The integrity of the proceedings. Will not affect the so-called pending investigation of open society. I invite Mr. Njero to guide us on who next. Thank you.
Another
Text 6. This Willis, and then we understand the application, right?
We understand.
So you cannot submit the whole day and expect magic. We should be reasonable, and they say, for wise, Chester, I'll give you 5 minutes.
Very well. Your Honor, I want to start by raising an issue and Section 8 of the Magistrates Court Act gives the authority to see what search warrants, not such warrants, which they abused by literally and Nairobi bungling him into a police vehicle, bail, to deny bail. The High Court must provide cogent, the term that is cogent evidence, and he keeps referring to some ghost creatures called agents of the respondent shouted at Integrity Center, and that's a very serious threat. They have not drawn the matrix to the so-called agents. Was it Governor Natembeya's wife? Were they governors? And this court must not listen to them. The accused person, Your Honor, civil servant. He is Soya County. He is a deputy party leader. At the time, the so-called ghost agents were shouting, he was only one advocate. Mr. Simiu and the rest of us were locked out. The court said that the seriousness of the offense,
I repeat, 1-1 is enough.
Lastly,
I don't know why we get this temptation. As the more I speak,
the High Court at Nairobi, criminal case number 48 of 2016, actual witness interference.
That indeed, as at 6:30 a.m. yesterday, the accused person had lost by Mr. Robert Rono is certainly not accurate. Number two, Your Honor, the place where they went to play Milimani residence. That is repeated. The order that they received to search the accused's premises had the following residences: Kibomet.
oh, come again.
First is
No, the second.
second is a place called Kibomet. Kibomet. Third is Nairobi residence in Kileleshwa. Okay. Were vandalized when they were searching his Kitale residence. Your Honor, looking at the order, which Your Honor you can have a look at. And therefore, Your Honor, we are appealing to you that the evidence that has been annexed to the affidavit is illegally obtained. 5 to the Evidence Act, Section 106, capital B, Section 4, subsection
What? You're on the 6th minute. The 6th minute.
I wrap up here. Please refer to the documents.
Are you ready to reason?
I yield, Your Honor.
Honest to the court.
Thank you.
Your Honor, I'll try to say 3 minutes at max, and you stop with 5 minutes. There is no certificate of electronic evidence annexing those pictorials. I didn't.
Slow. You left me a mile ago. The applications contain in
And in the absence of the electronic certificate, the annexures, Section 3 of the Judicature Act, lists the sources of law in Kenya that this court is called up. When we say the court to apply Article 49, to apply Article 50, we are asking the court to apply many constants. The right to bail is constitutional. And the purpose of giving terms is to compel attendance. Detention should never be used as a basis to punish an accused person who is still presumed to be innocent. Thank you.
Sanjeri, your last soldier. Is it your last one?
This one and then Dr. Amino. Then we are done.
Dr. Amino.
Thank you, Your Honor. Your Honor, I'm very privileged to appear before you to demonstrate that what I did recently in my second PhD in criminal justice. I would like this court to look at the whole history of the government and intergovernment officers calling themselves ES law, whereby if the government raises its own legitimate expectation, if that was the case, then that law must be narrowly, and I mean narrowly, tailored. How do we look into the classification of what the state has alleged? Classification, looking at the time to drive, the time taken to drive the accused, the miles involved in that journey, and how the accused was arraigned in court. Lastly, and please let the court make me understand, whether the arresting officer is the investigating officer and is the judge, and even if that statute contradicts the Constitution, in which case I believe it does, following the circumstances. I think it should, because I can substitute it. Your Honor, what I mean by literacy is not literary. Raises issues that can only be raised on discovery.
Well, you're acquitted yourself.
Thank you.
My running friend is Sundupi. I always appear with him in the cases. He had only one word that he wants to tell you. Only one word.
One word will take maybe 1 minute or less. First, we look at the charge sheet. Particulars refer to one. It is impossible to tell which one they mean, except for the use of the word God. Related to that is the particulars in the charge sheet under the law. I make the presumption that the court knows how to understand and understand those particulars which are suggesting that he has committed an offense of corruption, of conflict of interest. The particulars of conflict of interest have not been indicated. So that's what speaking is. If you look at count 2, the same problem of lack of particulars. So there is no evidence that demonstrates. We were told monkey see, monkey do. When the government itself violates court orders, citizens have no reason to. I do recall off the top of my head the governor of Istanbul who was charged with does not stand. The court has authority and discretion to give conditions that will ensure that the proceedings of this court are.
Because several counsels or advocates have spoken, they have made personal submissions. I would respectfully argue that and tell the audience that a reasoned ruling will be delivered much later. By the High Court. This has always been done by the Court of Appeal.
This one?
Giving reasons later.
Yes.
Has always been done by the Court of Appeal that the governor is released forthwith and you will deliver the ruling later. I also urge you very, very respectfully to listen to the nation, and there's no way you can be in Kenya for another country at home. Give them a free phone. And you will also be educating certain people and certain people, saying to you respectfully that you make an order before you rise.
Sorry, that is called, and it's
that the governor should be released on a free born.
You're a child of?
Born in the colonial days.
Colonial days.
I'm the child who received education in colonial institutions. Of sociology, anthropology, philosophy, when we had terms like the African mind, how the African thinks, and so on, from the colonial days. There's one thing I can make you very clear. The criminal law of Kenya has always been during the colonial days. It was abused during Mzee Jomo Kenyatta's days. It was abused during the Baptist reign.
I think the statement is home, the child. The statement is home.
They have now taken over the criminal law of the country. They are abusing it. The rule of law which we thought was improving is now in ICU. That unless we arrest the situation, nobody will have confidence in the country. The country could easily be classified as that it can come.
Daktari, if we can deal with Mr. Natembeya first.
Yes. You want to, what the charges you are given here, one can even pass this blood. The past comes. The governor is supposed to have corruptly received the sum of shillings 1 million. Can see that this is dishonesty. Dishonesty. The country because of that amount of money. That's on the first page. What is that? A full governor, 2 million, 168 shillings. Thirdly, Your Honor, probably to make one point clear. A constitution not to be meaningful, it must develop something called conventions. In some cases, something called conventions. You would expect that a charge against a governor of the country, the director, to satisfy himself that a case has been made out against Natembeya. Having regard to what you have been told, you was realistic to it. When did the DPP read the entire file? At least if I may say in favor of Charles Njonjo, he would read the entire file to satisfy himself that indeed a case has been made out to millions of people. It is therefore not surprising that the people in his own area were mad to him to read at home. Your Honor, may I say, draw your attention to the fact that I also have no jurisdiction in entertain the count that they have the document placed before this court. There's no jurisdiction at all. But a charge can be preferred against the governor. The way to deal with the governor is to use the impeachment proceedings that have been provided for in the Constitution. The governor, Natembeya, release him. Your Honor, one final question, or one final submission I may make to you. Please don't misunderstand me at all. What is required of a lawyer? What is required of a magistrate or a judicial officer is to be strong and to be courageous. In a mind in you very respectful, that rise to the occasion. The the country has gone down. And we need young people like yourself, John, who have got power, to see whether we can bring up and maintain the concept. Let the executive keep its own day, not to get into other days. As currently, it is not doing so. Other quotas and so on.
Mahatma.
Yes, there is a book here which we referring to impeachment in the Nigerian presidential system. That's why we have a lot of impeachments of for governors and so on. And I've noticed that the order for this book.
What is the title?
You know, I'm taking the title. It's impeachment in the Nigerian presidential system. I assure the very learned senior that we have captured.
Yeah, there's a lot of on impeachment they would rather die than have such a government in power. Just as some people, I'm sure are swearing that they would rather die than see Governor Natembeya in power.
Very well. Our father, the father, the profession, he has said it all. Give the governor free board. At the very worst, so that we don't play in the hands of his tormentors. Let there be no conditions. This man has been elected by his people. He has committed no wrong until that effect. So let's not talk about conditions. In fact, that bit, you want to please expand it. I plead with you. Expand it. Let him get his free vote or cash bill, let him leave. Even we believe, Your Honor, that you do the right thing. We have no doubt at all. I, for one, have no doubt. I know you are a good judicial officer. You believe in the rule of law, that today George Natembeya will walk out. No conditions have been sought, and he shouldn't even be there anymore. Let the man go and serve. He'll have his day in court. We thank you.
I'll start with the jurisdictional issue that has been raised by counsel, especially the very learned Dr. Aminwa, as to whether or not this court to entertain these charges. And that is related to reference, I believe. I haven't made reference, but I believe that's the position. In brief responses, this court's jurisdiction to entertain anti-corruption matters is provided of the ASECA. ASECA is a law. Point of law is ASECA. So this court has jurisdiction. The Director of Public Prosecutions is vested with power to institute criminal proceedings. Allow me to make two. Number one, I don't know whether counsel read the charge sheet. Count number one is conflict of interest. And not just that. Count number two. How could he have? The second correction, Your Honor, my learned senior, Mr. Masharia, if I don't treat it within the Republic, unless we are reading different ones. So that even the search in Trans Nzoia was by law, was sanctioned by law. So the arrest was proper. The searches were proper. ensure and promote an equal application, ensure and promote an equal application of the law to everyone, equal application of the law. Article 27, sub-article 4. Equal application of the law. Article 27, sub-article 4 of the Constitution. Properly, on the basis of which it could institute these proceedings, before you. I withdraw.
If you have withdrawn, I wanted to clarify that.
91 I call it different, so I withdraw. Your Honor, back to the question of bond as I conclude. Page 19, reported in the Kenya Law Report in 2010. Republic versus John Kahindi and two others, 2010 EKLR. It is at the footnotes of page 19 of the Judiciary Bail and Bond Guidelines in opposition of bail. Anyone can confirm because the guidelines are available online.
But the prosecution
does not need to avail an affidavit in support of an application for denial of bail. While other courts insist on it, not all courts insist on it. That's the import of that decision. It's cited at page 19 in the footnotes. The importance of that argument that we make is that even without an affidavit, compelling reasons can exist. And so that the argument by Mr. Otieno that if certain documents were removed or expunged, then there is no basis There's also the argument as regards bail that we have not.
You can't admit that know your pace, not abilities. I'm not doubting your abilities. You underestimated your pace.
Thank you. Your Honor, I was referring to. Did I say last? Thank you.
Last, you were attacking the challenge by Mr. Otieno.
All right, yes, thank you very much. So Mr. Otieno was of the effect that if there is no certificate under 106 Aminwa, in Mr. Ichesa's words, the first accused is a governor of a county, and he is not a lonely man. Verbatim, if I got it right. Objecting on, is it points of law or what you say?
As in, you have quoted my statement in my presence.
Yes.
You clearly misunderstood it, and you want to go to the next person without clarifying the court.
Sorry, Your Honor, I have not wrong in my interpretation, but in hearing you, I can't be wrong.
Points of fact, points of law.
Your Honor, I'm coming to the point of law. I'm still quoting him. You cannot be the point of law. I am coming to the point of law. And thirdly, I am reminded that my very good friend, senior Dr. Ndu, that the influence of the first accused is admitted by his counsel on his behalf. And that it is not far-fetched that of the Judiciary Bail and Bond Policy Guidelines talks about likelihood. Yes, Your Honor.
You should have said you need that.
I am done. That is my last point. Influence, there is a compelling reason you must deny bail. And standard of proof is on a balance of probabilities. I thank you for being patient with me. I am such a mouthy. And we argue that we have established compelling reasons to deny the first accused bail. Thank you, Madam Your Honor.
Your Honor, the Commission, could you add one of my colleagues who came in late? Honorable Jeremiah Kioni, Assessor Counsel, who will place him on record. We now able to come to do it right here.
It's now technically you are ruling on the matter. I possibly need one, we take a lunch break. Take a lunch. So the issues are into millions. I will try the best to do it in 1 hour. And Dr. Haminwa encouraged me to. Unfortunately, we have not been facilitated that way by our procedures. For the Court of Appeal, for the Supreme Court, they are facilitated properly by that actually can give ground of my abilities and competence. Which I do not wish. So we take a break. We resume at exactly 2 for the ruling. Much obliged.
Yes.